Professor Anil Kumar G, sir, Vice Principal, Kerala Law Academy, other dignitaries on and off the dais, very warm greetings to one and all present here on this delightful evening. It is with immense pride and joy that I stand before you, honored and delighted to host this distinguished gathering, which adds unparalleled value and prestige to this occasion. We are the first generation to feel the effect of climate change and the last generation who can do something about it, quoted by Barack Obama, former US President. Climate change represents one of the most significant challenges humanity has ever faced. It affects not only the environment, but also our economy, health, food security, and overall quality of life. Addressing climate change is crucial because it is deeply connected to social justice and human rights. In the midst of our distinguished gathering, we are privileged to host legal luminaries whose accomplishments speak volumes. Firstly, our sincere gratitude and admiration extends to our illustrious Dr. S. Ambika Kumari Ma'am, Professor and Dean, School of Law, Wales Institute of Science, Technology and Advanced Studies. Ma'am is a distinguished academician with an impressive track record in legal education and research. As Dean, Ma'am has been instrumental in fostering academic excellence and guiding the next generation of legal professionals. Her extensive experience and invaluable expertise make her a true asset to the legal fraternity. 11 scholars were awarded PhD under her supervision. She has published over 3 books in criminal law, family law, and CPC. Ma'am have over 30 research publications to her credit. She is also the recipient of Shigaram Patra Mahila Award and Women Empowerment Award from Mrs. Draupadi Murmu, Honorable President of India. She has also been a part of more than 20 national and international seminars. It's an absolute privilege to have you with us, ma'am, and we welcome you to this event. Esteemed guests, it is with great pleasure that we extend a warm welcome to Professor Dr. Asim Khan B. Patan, sir, Professor of Law and Associate Dean, School of Law, G.D. Goenka University. He has also worked as an Associate Professor of Law at School of Law, University of Petroleum and Energy Studies, Dehradun, between 2015 and 2019. Sir has also been Head Department of Media, Entertainment and Taxation Law at School of Law, UPS. Sir is an honorary editor of Public Knowledge Project and also has been a resource person for the World Bank Project and organized workshop on business and sustainability. He has been a resource person in workshop on environmental law adjudication by Chhattisgarh Environment Board. He is also a recipient of many research awards. He is also a recipient of ex-Prime Minister P.V. Narasimha Rao Gold Medal. We are absolutely privileged to have you amongst us, esteemed gathering, sir. I extend my warmest welcome to you. I extend a heartfelt welcome to Arun B. Unnithan, sir, Associate Professor, NSS Program Officer, Kerala Law Academy. As a dynamic and energetic individual, sir has successfully hosted over 100 NSS programs within the campus, demonstrating his commitment to creating vibrant and engaging experiences for our community. Sir is also one of the faculty convener of this event. Sir has not only nurtured the legal talents of our students, but have also served as a beacon of inspiration. I extend my sincere welcome to you, sir. Next, I am honored to express my heartfelt welcome to Advocate Nagaraj Narayan, sir, a distinguished figure in his role as Director of Kerala Law Academy Law College, Member Bar Council of Kerala, and my beloved teacher who has extended his consistent support to all the endeavors within this esteemed institution. His steadfast commitment to our academic pursuits and the various activities that shape the college's vibrant atmosphere is truly commendable. Sir, we welcome you to be a part of this event. Now, I extend warm greetings to Professor K. Anil Kumar, sir, the esteemed Director of Administration, Students and Faculty Affairs, Kerala Law Academy, whose wholehearted dedication has significantly enriched our academic and extracurricular pursuits, whose contributions to our institution and its students embodies the spirit of excellence. Thank you for your continuous support, sir. We welcome you to this auspicious event. A heartfelt welcome extends to Professor Harindran Kesa, Principal, Kerala Law Academy. Throughout our journey, we have discovered persistent encouragement from Professor Harindran Kesa. So your presence add immense joy to our prestigious gathering. I extend my wholehearted welcome to you, sir. Equally deserving of our warmest greetings, I extend a hearty welcome to Professor Anil Kumar Ji, sir, Vice Principal, Kerala Law Academy Law College, whose guidance have been pivotal in shaping and motivating our students, contributing significantly to the growth and success of our institution. I extend my genuine welcome to you, sir. With great pleasure, I extend my warm welcome to Professor Dr. Ajita Nair L. Ma'am, Professor, Kerala Academy, whose valuable guidance and mentorship have not only nurtured the legal talents of our students, but have also served as a beacon of inspiration. Hearty welcome, ma'am. Now, I extend my sincere and reverent welcome to our distinguished faculty conveners, Advocate Venchini Ponnan Sheila ma'am and Dr. Malavika J ma'am, assistant professors of Kerala Law Academy Law College, whose wisdom and strength form the bedrock of this extraordinary event. Last but not the least, a hearty welcome to our esteemed faculties, exceptional team of student conveners, diligent students, dedicated teaching and non-teaching staff, and the incredibly talented IT and technical teams. Your collective efforts have been the silent yet formidable force behind the seamless execution of this momentous event. This gathering of brilliant minds and dedicated individuals is a testament to the collaborative spirit that propels us forward. Thank you for being a part of this informative journey. Once again, I welcome you all to this valedictory session. Thank you.
Thank you, ma'am, for your warm welcome. I take this opportunity to welcome you too into the session, ma'am.
Now we have the presence of Dr. S. Ambika Kumari ma'am, Professor and Dean School of Law in Waynes Institute of Science, Technology and Advanced Studies. Ambika Kumari ma'am earned her LLB and LLM degrees from Kerala University and received her PhD from Pondicherry University. She worked as a professor at both Pondicherry Government Law College and Kerala Law Academy Law College. Ma'am is also a proud alumni of Kerala Law Academy Law College. It is an honor for us to welcome ma'am, who is a paragon of academic excellence. With an illustrious career as a professor and a rich background in law, her insights have inspired many and her commitment to education has left a lasting impact. We are privileged to have Dr. S. Ambika Kumari ma'am with us today to address the valedictory session. Ma'am, please.
Good evening. Dr. Asim Khan B. Patan, Professor of Law and Associate Dean, School of Law, G.D. Goenka University, Haryana. Advocate Nagaraj Narayanan, Director, Kerala Law Academy. Professor Anil Kumar, Director of Administration, Students and Faculty Affairs, Kerala Law Academy. Professor Harindran K., the Principal of the College, organizers and participants of the 20th International Seminar on Climate Change, Rights, Issues and Challenges, faculty members and students of Kerala Law Academy Law College, ladies and gentlemen, good evening to you all once again. I am indeed happy to participate in the two-day international seminar on climate change, rights, issues and challenges organized by Kerala Law Academy Law College and privileged to have been invited as the chief guest for the valedictory function. At the outset, I must say that I feel very nostalgic at this moment. Today, whatever I am is because of Kerala Law Academy. My association with the college spans nearly 5 decades. I joined Kerala Law Academy for LLB program in the year 1976. I was also fortunate to have worked, albeit for a lesser period, as a professor of law in Kerala Law Academy. The times then were very different from what it is today. Many changes have taken place. However, amidst the constant pull and push of time, Kerala Law Academy seems to be a constantly endeavoring to set higher standards every passing year through every student passing through its portals in the quest for excellence in legal education, if I may say with certainty, in the entire country for more than 5 decades. Thanks to the visionary late Dr. Narayanan Nair sir, the founder of Kerala Law Academy, whose stalwart leadership and his blessings upon his students and faculty members continue to drive this institution to great heights. I profusely express my deep sense of thanks to my host, most respected Guru, Professor Dr. N.K. Jayakumar sir, former Vice Chancellor of Nuvals Kochi and formerly Professor Kerala Law Academy, who shaped my destiny with constant care and concern, which inspired me to become a teacher. So, as an alumna or as well as Dean of School of Law, Wales University, Chennai, I take this opportunity to thank my alma mater, its founder, and my teachers for shaping my course of destiny, and to the organizing committee. I thank you for the honor of asking me to share the stage with some of my colleagues and other jurists and legal luminaries. Climate change is a global problem today. The continuing change in climate across the world is posing threat to our environment and society as a whole. Countries around the world multilaterally are taking efforts to reverse climate change and stop global warming. However, we are constantly witnessing a rise in temperatures every year, which pose a serious threat to all living creatures on this planet. Climate change is the single biggest health threat facing humanity. Climate impacts are already harming health through air pollution, disease, extreme weather events, forced displacement, pressures on mental health, and increased hunger and poor nutrition in places where people cannot grow or find sufficient food. Climate change threatens the effective enjoyment of a range of human rights, including those to life, water and sanitation, food, health, housing, self-determination, culture, and development. Studies done on climate change has shown that since the year 1880, the average global temperature has increased by a little more than 1 degree centigrade. Almost two-thirds of the warming has happened since 1975. Almost half of global carbon dioxide emissions were emitted since 1990, thereby mounting the mitigation challenge. Since the Paris Agreement 2015, emissions have increased annually with a temporary drop in 2020 caused by the COVID-19 pandemic crisis, the largest annual reduction ever observed. However, no significant structural changes in the global energy system have been recorded so far, according to reports from various research institutions. All these go to prove how carbonized the world economy has become. It is an urgent need to decarbonize the world economy, and that too urgently, to further prevent aggravation of the present crisis. Gone are the days when experts spoke of reversing climate change. Today, we have come to a situation primarily because of inaction that all countries, rich and poor, must adapt to climate change. I came across an article written by the managing director of the International Monetary Fund, Christina Georgieva, in which she highlights about a recent report by the United Nations Intergovernmental Panel on Climate Change, which had spelled out the dramatic consequences of failing to curb the rise in global temperature and adapting to a hotter planet. Adaptation should address risk from climate change and extreme weather, for example, by safeguarding agriculture, managing the impact of rising seas, and making infrastructure more resilient. So, we are now focusing on how to adapt and live with this new scenario. However, it is my strong belief and opinion that climate adaptation alone is not enough. Unless global temperature is stabilized by strong mitigation, adaptation will become impossibly expensive. Yet, countries can still reap large benefits from investing in resilient growth and integrating adaptation into development strategies. But as it is said, there is light at the end of the tunnel. Let us be reminded about the Conference of Parties, that is COP28, held in December 2023 in Dubai, which was particularly momentous as it marked the conclusion of the first global stockade of the world's efforts to address climate change under the Paris Agreement. Having shown that progress was too slow across all areas of climate action, from reducing greenhouse gas emissions to strengthening resilience to a changing climate, to getting the financial and technological support to vulnerable nations, countries responded with a decision on how to accelerate action across all areas by 2030. This includes a call on governments to speed up the transition away from fossil fuels to renewable, such as wind and solar power, in their next round of climate commitments. You have no doubt heard the maxim from Roman statesman and lawyer Cicero, Salus Populi Suprema Lex, which means the welfare of the people is the supreme law. This line is often quoted for a very good reason. Even after thousands of years, the principle remains valid. The welfare of the people is the ultimate. The very existence of law is for the welfare of the people. This, in essence, in every context, would rightly mean the welfare of the tripartite planetary cluster. That is the welfare, peace, and prosperity of humans, the welfare of every other species over which we exert so much influence, and the welfare of our natural world. This is where the full force of law must be brought to bear on achieving every ambitious goal set by the global community against the climate change. The so-called environment rule of law sets the foundation to achieve this. Since the Rio Earth Summit in 1992, there has been rapid growth in environmental laws. Over 170 countries now have environmental framework laws. Some 150 countries have established the right to a healthy environment in their domestic legal frameworks, either through their constitutions, laws, jurisprudence, or participation in regional human rights treaties. At the international level, the Human Rights Council resolution recognizing a human right to a clean, healthy, and sustainable environment raises the bar even higher. But it is just and enough. Top-level laws and rights have not been translated into specific and widespread environmental laws that are effectively implemented at all levels. All of us are aware that with the rapid rise in global warming, the glaciers are melting fast, and subsequently the seawater levels are rising. Due to this, the country is situated on the oceans, and the people living on it are the most vulnerable. There is a new academic concept that has developed called as climate refugees or environmental refugees. This group of refugees are the most vulnerable of all, as they would not be able to go back to their place of birth, as their land would be submerged in the sea. So what will such people do? Where will they go? What can law do to them? How does the international humanitarian and refugee law address this gap? These are pertinent questions that the modern jurisprudence must address. Beyond developing national framework legislations, the need is to analyze and strengthen laws relevant to all sectors, namely tax laws, company laws, security laws, trade practices laws, environmental laws, energy laws, then land use and planning laws, transportation laws. You may virtually any law. You name virtually any law, and countries likely need to climate proof it. That is the need of the hour. These are good framework climate laws which over 30 countries have put in place. Good framework climate laws have many elements which we do see signs of in the countries across the globe, such as long-term emissions target for 2050 in line with the science, risk and vulnerability assessments, carbon tax and carbon dioxide emission performance standards, national level climate change council as in Kenya, participation of indigenous communities in protection of the environment, establishment of climate change fund are some of the features that countries have adopted to mitigate climate change. Other countries can take examples from it and through legislations can implement such measures. The world has to grow sustainably, and so countries need to invest in environmental protection through law. As outlined by UNEP's International Advisory Council for Environmental Justice, this means 7 things. First, fair, clear, and implementable laws at every level, covering every sector. Public participation in decision making and access to justice and information in environmental matters in accordance with the principle 10 of the Rio Declaration. Accountability and integrity of institutions and decision makers, including through the active engagement of environmental auditing and enforcement. Clear and coordinated mandates and roles across and within institutions. Accessible, fair, impartial, timely, and responsive dispute resolution mechanisms. This includes developing specialized expertise in environmental adjudication and innovative environmental procedures and remedies. Recognition of the mutually reinforcing relationship between human rights and the environment. And finally, specific criteria for the interpretation of environmental law. In this context, I wish to congratulate Kerala Law Academy, Law College for organizing this important deliberation on a very pertinent topic of global need. I am sure that the participants have gained mammoth knowledge and insight into various aspects of climate change, about the rights of all species, the issues that we face, and the challenges that are to be overcome through legal framework. I urge that all participants to build upon these deliberations and come out with concrete proposals for concerted action nationally as well as globally by conducting research and bringing out your findings to mitigate climate change effectively. My best wishes to all of you, and I conclude my address by once again thanking all of you for the invitation and the nice words spoken about me. Thank you.
Thank you so much, ma'am, for your valuable words.
Today, we're also in the presence of an eminent personality, Professor Dr. Azam Khan B. Pathan, sir, Associate Dean, School of Law, GD Goenka University. He's a leading expert in the field of energy law, environmental law, and comparative public law, holding a doctorate specializing in climate change. He's also a recipient of many research awards, including ex-Prime Minister P.V. Narasimha Rao Gold Medal. It's a matter of immense privilege to welcome Dr. Azam Khan B. Pathan, sir, for the presidential address. Sir, please.
Thank you, Rukmini, and thank you, Srinidhi. A very good evening to one and all here for this 20th International Seminar on Climate Change Rights, Issues and Challenges. I extend my greetings and this good evening to all the dignitaries who are virtually present here for this valedictory ceremony, especially Professor Dr. Ambika, Advocate Arunji, Professor Dr. Harinder Kumarji, Dr. Dakshina Saraswati ji, all faculty members, all participants, paper presenters, all scholars, and indeed all students, and ladies and gentlemen. Let me extend my greetings for this very auspicious occasion and this valedictory ceremony of this 20th International Seminar on Climate Change Rights, Issues and Challenges. I'm sure lot many things that must have been deliberated during this entire international seminar, and very rightly pointed out as well by Professor Dr. Ambikaji as well, certain important, nuances and important, the points which are very core at this juncture in this 21st century when we are talking in the context of climate change issues and challenges. Let me remember at this juncture, and let me also, push you all towards that particular thinking where 11,000 and odd population of Tuvalu country, Tuvalu, small island in South Pacific Ocean, indeed, which is nothing but, club of almost, 9 small islands, small islands, which is known as Tuvalu Islands, where Tuvaluan people, almost 11,000 and odd, they are staying. Indeed, they are also afraid. They are also, thinking. They are also, daily understanding the threat of this particular, climatic change and this global warming. Indeed, daily, which is high risk, we can say the island in this entire world's planet, Tuvalu Island, they are continuously thinking at any time, any day, this ice melting or this Antarctica region or this particular, we can say, these Arctic regions, the glaciers will melt because of this climate change and this global warming, and their entire population and their entire island will submerge in the ocean due to this climate change. They are continuously thinking. They are continuously, it is there in their mind when they are, doing their core daily in their daily life. But now the question is that how exactly the entire world is going to tackle with this particular issue. We are continuously talking about, the responsibility of all over the world of developing nations, developed nation. We have carved out indeed, the managerial principle based, United Nations Framework Convention on Climate Change, which was pointed out by Professor Ambikaji as well, to tackle with this issue of, this climate change, which is based on common but differentiated responsibility principle. But there are many important, the gray areas. I will highlight that particular gray areas, those issues and challenges, and how exactly new kind of advocacy, new kind of policy formulation, new kind of, we can say the action plan that can be carved out, new kind of climate consciousness which is required now in this present day context, not only from the government, not only from the nation state, but at the same time from down to, up approach, from bottom to up approach is required. That is from last person of the society to the apex, that is nothing but the policy maker. The new overhauling, the approach overhauling thinking is required to tackle with this particular issue of submerging these, islands, or not only the submerging of the islands, but at the same time, the many coastal region, Kendrapara district in, more specifically in Orissa, how exactly this coastal region, swept away because of these, oceanic, changes. That is also the best example as far as concerning to India, when we are, facing with, and we are, tackling with this particular issue of climate change. But what about those 11,000 and odd population of Tuvalu country? Let me take you back when we are talking in the context of, this climate change rights issues, more specifically rights issues and challenges. In 2007, these Tuvalu people, indeed, they had approached long back before Inter-American Commission of Human Rights, taking this particular grievance, that due to this global warming, there is a lot of changes, in ocean and the level of, the oceanic, water. And there Tuvalu, this island, it may get submerged, and it is getting submerged as well. Out of 9, different tolls, 9 different, islands, small island, already 2 islands of those Tuvalu people already submerged, in the ocean. So with this particular grievance, they had approached before the, Inter-American Commission on Human Rights long back in 2007 through the petition. But the problem in front of Inter-American Commission on Climate Change, it was that there is no specific, enforcement clause against any particular, the country who is not exactly shouldering their responsibility to cut or to reduce their carbon emission, which is one of the important factors of greenhouse gases, and consequently, the mean temperature level increase, and consequently the global warming. So indeed, they had pointed out long back in 2007 that America indeed not shouldering the responsibility of cutting their carbon emissions, and they are the biggest emitter of carbon emissions, and they should be held more responsible for the plight of these Tuvalu people and submergence of their island, and they should be held, responsible, because they are not shouldering their responsibility. They are not exactly shouldering their responsibility, and they have come out that Kyoto Protocol, the then Kyoto Protocol, that time it was, applicable, but after, this new regime 2015 onward, this Paris Agreement, which has replaced, we cannot say replaced, but it is the new alternative arrangement after the expiry of the Kyoto Protocol, which we are seeing. But that time, the United States has not exactly accepted the legally binding document called Kyoto Protocol and not reduced the, the carbon emissions. So these Tuvalu people, indeed, these island people, Tuvalu, they petitioned before the Inter-American Commission on Human Rights, and they were asking, they were representing this particular point that the country like United States of America is liable because of they are not reducing their carbon emission. So they are liable to pay the compensation because these two island out of 9 island in that particular region of Tuvalu, in the South Pacific region, South Pacific Ocean, submerged beneath the, the ocean. And because of that, they are liable for that particular, the thing, because of, their agriculture, their particular crop, those were destroyed, those were submerged. So they are liable. It is the matter of human rights. They were representing this particular point. They were stating this particular point. Excuse me. But the question before Inter-American Commission on Human Rights, it was that there is no specific, the provision in, more specifically, United Nations Convention, Framework Convention on Climate Change, to impose the liability on a particular, the state who is not shouldering their responsibility, neither in United Nations Framework Convention on Climate Change, that particular, mechanism of enforcement that has been defined and designed, nor it has been defined and designed that time in Kyoto Protocol 1997, which had come into force in 2005. So there was this particular issue in front of the entire, the globe as well, and more specifically, Inter-American Commission on Human Rights. Indeed, these Tuvalu people, they were also, representing their concern because of the submergence of their two islands beneath this oceanic water. Certain people, they became, the climate refugee. Or in coming time, they will become the climatic refugee, climate change induced refugee. So Inter-American Commission was not having answer in front of them, because even the climate change, even, Refugee Convention of 1951 is also silent, and it does not exactly recognize, the climate change induced refugees. So Inter-American Commission could not give any kind of remedy to those Tuvalu people in 2007, and that particular petition, indeed, that was rejected from this Inter-American Commission on Human Rights. Now you can see that this particular particular perspective. But at the same time, there are also other important perspectives as well. This climate change regime, one side, is mainly focusing on managerial approach, managerial principle. It is based on managerial principle. It is based on consensus. This entire, international legal framework which tackles with this climate change issue, it is based on only one particular principle. That is only limited to managerial principle, only management of, this carbon emission. There is no specific, stringent enforcement body, which is just like or similar to the WTO, and WTO with reference to, GATS Article 20, comply with certain environmental requirement. As a more stringent, the mechanism, that kind of mechanism, indeed, it is not exactly, reflected neither in United Nations Framework Convention on Climate Change, nor in Kyoto Protocol in 1997, nor more specifically, this Paris Agreement of 2015, which is still, in this transition time, it is applicable, which has mandated, more specifically intended, we can say intended national, we can say the contribution from different countries. If country will say that okay, we will reduce this kind of, this much, emission to the level of 1990 or to the level of a particular year, that will be taken into account, and that will be reviewed every after 5 years by the Secretariat of United Nations Framework Convention on Climate Change. So you will find that this particular, the entire mechanism which has evolved, it has certain, we can say, certain gray areas. It has certain, in this mechanism, it is not exactly having the teeth, you can say that. There is no specific, the enforcement mechanism in this international, the mechanism which is defined and designed for combating these climate change related aspects. But now you will find that, the trend has changed, because more specifically, if you will see the ozone depletion related, the mechanism, that is Montreal Protocol to, other, protocols, where the mechanism which has defined and it has been, made mandated, and it is made, enforceable as well, due to the threat to the humanity. If there will be ozone layer, if it will be there, ozone layer will be vanish automatically. This ultraviolet, the rays, it will have direct impact on the human being, and it will kill to the human being, or it will have the cancer. So due to this kind of, threat, the new kind of mechanism to deal with this, the ozone depletion related, the problem, it has come into existence, and it is having, more teeth for the enforcement as well. But that kind of mechanism at the international level, it has not exactly yet, finalized. Lot of debate, discussion, no doubt, lot of meetings in Conference of Party, right from 2021 Conference of Party to till today, you can see 26, 27, and now forthcoming 28 Conference of Party under this, beneath this United Nations Framework Convention on Climate Change, it will take place. But through this particular, the negotiation, through this Conference of Parties which are, or who are deciding, discussing, through their, the approach, through their efforts, new mechanism not yet, visualized. But different countries, different, regional organization, different, we can say, European, commissions, European Union as well, and different, countries, and different countries, judiciary, they are coming up, with this particular, change trend, where this climate change or adverse impact of climate change, it is connected with the human rights. It is connected, and it is being considered as a part and parcel of human rights. Adverse impact of climate change recently as well. Now I will be, talking in coming, immediately after this particular point, I'll be talking about that particular aspect. How exactly trend is changing. How exactly entire world is thinking to have change policy, to have change, framework, to have, this climate change related, the consequences which the different countries they are facing, to curb those particular, the consequences based on their available existing legal framework in their domestic legal system. And the best example indeed to this reference, let me quote here, which I was going through, one of the important work of Miss Kathleen Visen and Mr. Ashish Chaturvedi. Recently they have, published this particular, their article under the caption of Restoring Earth's Right to Good Health, where they quoted very important, example, and I'm going to, quote those different example, how now new kind of human rights wave is, being championed to take care of the consequences, adverse impact of these climatic changes in the different legal systems, domestic jurisprudence, where Mr. Ashish, in his work, he, specifically stated that European Court of Human Rights, they found that government of Switzerland, they found guilty of violating the rights of a group of women senior citizens of a Switzerland civil society group. And they noted that government action to curb emissions were inadequate and had failed to protect women against the impact of climate change. Means, see, the different countries, including Switzerland or different nation states, domestic legal system, they are deliberating, they are, bringing, new legal propositions in their domestic legal system, in their, judicial, structure, in their judiciary. And more specifically, European Court of Human Rights is saying that the government action to curb the emissions were inadequate and had failed to protect the women against impact of climate change. And they have directed as well to the Swiss government that you have to have the specific action to curb the situation of emissions at domestic level based on the rights of the women, based on the human rights of the, the senior citizens and women. Similar example, let me quote you here, in the case of State of Netherlands versus Agenda Foundation 2019. Indeed, here what happened, the apex court had given, direct directions indeed towards this particular, greenhouse gases emissions, or more specifically, carbon emissions. In this particular, what happened, they had indeed, taken into consideration where, this district court and appellate court, they had given certain important, direction in favor of, Agenda Foundation, saying that this is the responsibility of government of Netherlands to reduce the emissions, carbon emissions in their, we can say the domestic jurisdiction. This particular, directions from the district court, it was given in appellate court. This particular direction, it has been supported. So becoming, aggrieved because of this particular order, excuse me, order of this district court and then court of appeal, here State of Netherlands, they approached before the, the Supreme Court of Netherlands. And you will find, very interesting finding in this particular case. Very interesting, in this particular case, finding on appeal, what happened, this Netherlands court, Supreme Court, affirmed the decision of, we can say, the district court and appellate court, and acknowledged that there is direct obligation on the part of the state to protect the right to life. One side, they stated. And consequently, these emissions is affecting the right to life. And then they further, again, they have also quoted, excuse me, in this particular case of 2019, that European Convention on Human Rights article number 8, which says that right to private and family life as well, which is getting disturbed. Not only the right to life is getting disturbed because of the emission, because of the adverse impact of this carbon emission. So based on the human right, based on, you can say, that right to life, based on European Convention on Human Rights, based on UDHR, Universal Declaration on Human Rights, more specifically Article 3 of Universal Declaration on Human Rights, which recognizes right to life as well. So not only, one particular state, nations, the legal system or judiciary, they are, working now in their legal discourse and their legal, the jargons, or in their, legal instruments, where they are recognizing the right to life, they are recognizing the human rights. This adverse impact of, more specifically of climate change is against the human right, against the right to life. More further, you will also find that there are other instances all over the world, including the Argentina, state as well, Argentina as well. In the case of Sachi and others, and Argentina and others, they are important, the communication to this United Nations Committee of Child's Right. What exactly was there, the communication? Indeed, they communicated that there is direct violation of their rights under UN Convention of Rights of the Child by Argentina and other, the countries and states as well, including Brazil, France, Germany, and Turkey. Excuse me. They stated that in communication that these countries, they are not reducing the greenhouse gas emissions to an adequate, level, and they fail to curb these carbon emissions, and there is direct and indirect, the consequences on the citizens of those, the country, including children. No doubt. This Committee of the Rights of the Child of United Nations Organization, they indeed rejected this particular communication based on this particular ground that those states are sufficient enough, to take care of the carbon emissions. This particular state, right from Brazil to Turkey to France and Germany and Argentina, they are taking care, domestic legal system, they are taking care of the carbon emissions and reduction of carbon emissions. They are self-sufficient to, take care in their regulatory, the aspects in the countries. So based on this particular, version, indeed, this Committee of Child's, the Rights of United Nations Organization, they rejected this particular communication from these, 16 children. But at the same time, committee has also observed, this Committee of Child's Rights, United Nations Child Rights, they have also observed that there are certain negative, consequences on the human, in the living of the human and their right to life as well. Right to life as well is getting impacted because of these carbon emissions, and especially, children are getting more affected. They have observed this particular aspect. While dealing with this particular communication, so you will find that the trend, you will find that how exactly in different countries, the trend is coming out. The new trend is coming out. Now in this backdrop itself, you will find that now new jurisprudence in India as well, it is getting evolved. And the best example is the example of this, the judgment of Supreme Court in Ranjit Singh versus Union of India recently, which has been, dealt, by way of, interim application which had come before the Honorable Supreme Court with reference to, great Indian busters issues. Buster, that is nothing but, heavyweight, bird which is found in Gujarat and more specifically in Rajasthan states. Where you must have also come across recently in this month itself that Supreme Court of India is coming and saying that not exactly in its fullest extent this particular right against the adverse impact of climate change under Article 21, it is being articulated from the side of Supreme Court, the bench headed by Chief Justice of India, Justice D.Y. Chandrachud. Justice D.Y. Chandrachud, in this particular, the order, the case which had come before the Supreme Court in 2019, in the 2021, the Supreme Court, had, directed and had brought, complete ban on, more specifically on these solar power based lines which were spread in these, both state in Gujarat, and then other side, the Rajasthan. More specifically in a 99,000 square kilometer area. So they had brought, Supreme Court by the direction in 2021, they had brought the complete ban on that particular, solar power based lines, electricity, high voltage line, overhead high voltage line in that particular, the region. Because this petition in 2019 had come before the Supreme Court as protection of biodiversity, as protection of, this critically endangered species of great Indian bustard, that is nothing but the birds, heavy-weighted bird, which is found in these two states, that they are, getting, killed because of this collision of, different heavy voltage line, overhead heavy voltage line, and because of that, this critically endangered species of this great Indian bustard is getting, less and less. They have recorded that already, only 200 to 300, species are only remaining, and that too getting, killed because of this, high voltage, wire line, which is, there for, solar power based energy, which is mainly, those projects are there that in the state of Gujarat and Rajasthan. So complete ban it had come in 2021, but that has been, reopened. That has been reopened in this particular, the final order, we can say, in the month of April only. This month only it has come out, where Supreme Court has recognized and reconsidered their earlier, order, and they stated that, and they have, appointed the, the specialized committee to look into the feasibility of, underground wire, high voltage wire, and overhead, high voltage wire in that particular region. What can be the feasibility where biodiversity one side can also be protected, and other side the commitment, international commitment to reduce this carbon emission by way of, non-fossil fuel based, energy, because based on those, solar power based energy projects are there in this state of Rajasthan, and then in that particular region, and then state of, Gujarat. And this is nothing but towards the commitment of, India, based on National Action Plan of 2008, and then based on 2015, nationally intended contribution which we have adopted to reduce the carbon emission, and moving towards, non-conventional energy, base, or more specifically solar energy base electricity and solar energy based power to the different industries all over the, the country. So here there is some or the other way reconsideration, from the side of Supreme Court in this particular case. But here very interesting, the jurisprudence it has evolved, which is getting evolved all over the world, not only in India. But India, in the first time, you will find that based on the jurisprudence of Article 21, based on the jurisprudence of Article 14, the first time in this particular case, Ranjit Singh and others versus Union of India, in this particular case, first time Supreme Court is saying that particular legal proposition
Sir, you are muted.
yeah what exactly I was saying, that this particular judgment is, the judgment which is giving, certain important inputs similar to, the other nations, other part of the world where human right jurisprudence, right to life, the jurisprudence, it is being taken into account while dealing with this climate change and adverse impact of climate change. Supreme Court of India is first time in, the Indian continent is saying that There is fundamental right to the citizens of the country. There is right against, adverse impact of climate change under Article 21. First time Supreme Court of India is articulating that particular, we can say the legal proposition. No doubt I am saying that this particular, the version, this particular legal proposition that has not come, in the operative, the order of the Supreme Court. But this judgment has, opened the door for the scholar. This particular judgment has opened the door for the, environmentalist. This particular, the judgment has opened the door that how exactly now, even climate change related consequences can also be dealt based on the human right jurisprudence, based on the, the fundamental right jurisprudence, based on the, fundamental rights guaranteed in our Indian Constitution. So that kind of, important, the rights, important, issues, important challenges we have to face and we have to tackle. And we have to bring, the new analysis. And new analysis is possible based on the discourse of human right-based jurisprudence as far as concerning to this climate change regime, because it is directly going to have, direct adverse impact on the human being. Because whatever, the legal framework or international legal framework which we have brought precautionary approach, we have brought polluter pays principle, we have brought, by way of this Rio Declaration on Environment and Development, this particular conference, Rio Declaration, where we have seen that principle number 15, principle number 16, which is talking about precautionary approach, which is talking about polluter pays principle. But this particular approaches is having some or the other way shortfall. Those are more specifically dealing only, those particular principles are dealing only how we can make liable or how we can, fix the responsibility and liability of those polluting, the industries. But now this new jurisprudence is evolving. Human rights based jurisprudence is evolving, which is directly bringing, the responsibility and liability of the state and state instrumentality. Because earlier we were not able to check and challenge and go before the Supreme Court of India for the adverse impact of climate change. But now, after articulating this, the human right perspective within the legal framework of climate change, and this new interpretation that adverse impact of climate change is also against the fundamental right guaranteed in Article 21, we are now able to approach before the Supreme Court of India for asking that it is also the violation of, the fundamental right guaranteed in Article 21, that is right to life, dignified life, right to life with pollution-free environment. Now this is the new extended version. And now onward, from this particular point onward, you will find that in our Indian context, in our Indian, the jurisprudence, environmental jurisprudence, now new kind of litigations, climate change based litigations is going to come before the Supreme Court. New kind of advocacy is going to come before the Supreme Court, because that trend already started. We have seen, more specifically in Switzerland, we have seen more specifically, in Dutch, we have seen more specifically in Argentina, we have seen in Tuvalu, we have seen, in other parts of the world. That was not reflecting, more categorically in our Indian jurisprudence. But now, because of this particular new version, new interpretation, which is kept open from the side of Supreme Court, new litigation, new advocacy, new policy, new kind of, thoughts towards human rights elements, infusion of human rights elements in existing, the constitutional jurisprudence is going to, occur, which will deal the consequences of, this climate change and adverse impact. So I am sure, this is going to have a more interesting journey, and our role as an academician, as a researcher, as a student, as a stakeholder is very, very important. And more specifically, the law school's role is also very, very important, because the curriculum, advocacy, then different, law school structure, different, the legal jargons, that has to be accordingly interpreted, and accordingly it has to be analyzed inside the classroom, outside the classroom as well. And it should be reflected in different research as well. So I think by that way, we will be tackling this, this climate change related issues. But at the same time, I find that very, very important point, apart from the law, legal jargons, human rights jargons, human rights advocacy, there is also yet another important platform which is required to be infused in international, we can say the legal framework and domestic legal framework. That is nothing but the climate consciousness. Because there is still, we can say the cognitive bias is there. There is still, you will find that we know ourselves that driving, four-wheeler, I myself know that driving four-wheeler, continuously, it will have, more emission of carbon because of my petrol vehicle or because of my diesel vehicle. We know, I know, you know, but we never take that kind of step. At least out of 7 days or 6 days, we should have at least 1 day's, our bicycle driving for reaching to our destination. We know everything. That is nothing but, the cognitive bias in the mind of the people. That should also be, we have to have that kind of, the movement as well to remove that particular cognitive bias, and to have, more effective, climate change consciousness as well. We know ourselves that, more air conditioning inside our house or outside our house or our, workplaces, it will have adverse impact on the climate and consequences on that, directly on that Tuvalu Island. We are knowing that in the backdrop of our conscious. We know that you, me, you all here participant, all along 149 participants are here, 43 participants are there. We know this particular thing, that air conditioning is going to create, a lot of these greenhouse gases. But most of the time we don't dare to, use the natural, we can say air conditioning. Or at least in a month, or at least in a 1 week, we don't take that kind of steps which can contribute towards, the reduction in these carbon emissions. So that particular advocacy, that particular, climate consciousness, that particular, movement for removing that cognitive biases as well is also equally important, besides, dealing with this legal framework and policy framework as well. So I hope that with this particular, the points, we should, proceed, ahead in many important, research area, and we can contribute in many areas as well to tackle with this, climate change related challenges in this 21st century. I wish entire, this organizing team of this 20th International Seminar on Climate Change, Rights, Issues and Challenges. And I extend my thankfulness to the entire, Kerala Law Academy for inviting me for this valedictory session. Thank you so much.
I extend my heartfelt thanks to you, sir, for your valuable words of wisdom. And we are extremely honored and privileged to have you with us.
Gratitude is a mark of a noble soul and a refined character. From the bottom of my heart, I welcome Advocate Arun V. Unitan Sir, Associate Professor and NSS Program Officer, Kerala Law Academy Law College. He is a vibrant and enthusiastic teacher who is an inevitable part of all the events organized by Kerala Law Academy Law College. Sir is a multifaceted person who has the expertise of coordinating various events under the aegis of National Service Scheme. With immense pleasure and joy, I would like to invite Advocate Arun V. Unitan Sir to deliver the vote of thanks to this valedictory session. Sir, please.
Thank you. Good evening, one and all. Respected dignitaries, Dr. S. Ambika Kumari Ma'am, Professor and Dean, School of Law, Wales Institute of Science, Technology and Advanced Studies, Professor Dr. Asim Khan, B. Patan sir, Professor of Law and Associate Dean, School of Law, GD Goenka University, Advocate Nagaraj Narayan sir, Director, Kerala Law Academy and member, Bar Council of Kerala, Professor Anil Kumar K. sir, Director, Administration, Students and Faculty Affairs, Professor Harindran K. sir, Principal, Kerala Law Academy, paper presenters, faculty conveners, student conveners, other distinguished invitees, my colleagues, and dear students. I consider it an absolute privilege to present the vote of thanks to all those who have gathered here to be part of the 20th International Virtual Seminar on Climate Change, Rights, Issues, and Challenges, a highly coveted gathering put forth by Center for Advanced Legal Studies and Research and KLA, Center for Environmental Science and Law, under the aegis of Kerala Law Academy Law College, in association with IQAC KLA. Climate change. It is a global challenge that transcends borders, politics, and cultures. By addressing these issues head-on, we must take critical steps towards justice, equity in our global response to climate change. Now, to fulfill the duty bestowed upon me, it is with sincere appreciation that I express my heartfelt thanks to each and every one of you. First and foremost, I extend my deepest gratitude to the late Dr. N. Narayanan sir, the esteemed founder of Kerala Law Academy Law College. His vision and leadership continue to inspire us all as we organize events of this nature. I extend my profound gratitude for his enduring legacy and impact it had in our institution. I extend my vote of thanks to Dr. S. Ambika Kumari, ma'am, Professor and Dean, School of Law, Wales Institute of Science, Technology, and Advanced Studies. We sincerely thank and acknowledge the generosity and readiness shown by ma'am to accept our invitation in spite her busy schedule. Ma'am's profound insights have not only deepened our knowledge, but also reignited our passion and commitment to advancing the field of law with renewed dedication. Her expertise in the legal arena makes her a stalwart among us. On behalf of Kerala Law Academy and on my personal behalf, I extend a hearty thanks to you, ma'am. I take immense pride in expressing my gratitude to Professor Dr. Asim Khan P. Patan sir, Professor of Law and Associate Dean, School of Law, GD Goenka University. Sir, your remarkable contributions to the field of law, especially in areas of climate change and environmental law, have not only enlightened this gathering, but also inspired us to take action. Sir, on behalf of the Kerala Law Academy family, and also on my personal behalf, I propose a sincere thanks to you, sir. We are truly indebted to Advocate Nagaraj Narayan sir, Director, Kerala Law Academy Law College, member, Bar Council of Kerala. Sir's constant support has been a cornerstone for all the activities in our college. Sir, your vast knowledge and your capacity to lead us, both with vision and compassion, are truly commendable. I propose a sincere thanks to you, sir. Now, I would like to extend my heartfelt thanks to Professor Anil Kumar K. sir, Director of Administration, Student and Faculty Affairs, Kerala Law Academy Law College. As a brilliant academician with extensive experience in legal education, he sets a standard of excellence that we all strive to achieve. His skills and expertise in administration are unmatched, and he is a role model for all of us. His support and guidance have been invaluable to each and every one of us. We are truly grateful to you, sir. Next, I would like to express my gratitude to Professor Harindran K. sir, Principal, Kerala Law Academy Law College. Under your leadership and guidance, our achievements have flourished. From the depth of my heart, I offer heartfelt thanks to you, sir, for the never-ending support and dedication to our collective efforts. Now, I would like to express my gratitude to Professor Anil Kumar G, sir, Vice Principal, Kerala Law Academy Law College, for his wholehearted support to this event. We sincerely appreciate your invaluable contributions to this event. Your commitment and encouragement have been a key in making this event a success. I propose my heartfelt thanks to you, sir. Next, I would like to extend my thanks and gratitude to Professor Dr. Ajita Nair L. Ma'am, Professor, Kerala Law Academy Law College. We deeply appreciate her generous spirit and her role in guiding us both in planning and in the execution of this event. Ma'am, I extend my heartfelt thanks to you. And without a doubt, I also extend my gratitude to Dr. Dakshina Saraswati Ma'am, Associate Professor and General Secretary, Moot Court Society, Kerala Law Academy, whose tireless efforts and steadfast commitment are a testament of her passion for excellence. In acknowledging her pivotal role, we extend not only our heartfelt gratitude, but also our deepest admiration for the immeasurable value she brings to our institution. Thank you, ma'am. We extend our deepest gratitude to you. I also extend my gratitude to our dedicated faculty conveners, Advocate Ranjini Pananshila ma'am and Advocate Malaviga J madam, Dr. Malaviga J ma'am, Assistant Professors, Kerala Law Academy Law College. Their tireless efforts has formed the bedrock for this momentous event. A heartfelt gratitude is also extended to our diligent student conveners like Arya M.A., Nandakishore, Megha, Lakshmi Ramesh, Roshni, Roshan, Anjali Gurunath Naik, Alka, Ashwini, Jayaprakash, Kirti, Amrita, etc. for your enthusiasm and dedication in organizing this event. Your commitment have been nothing short of remarkable. I sincerely thank you for the tireless efforts and hard work in making this event reach its epitome. Last but not the least, I would like to acknowledge the contributions of our faculty members, students, entire teaching and non-teaching staff, and the IT and the technical team whose tireless efforts behind the scenes have ensured the seamless and execution of this momentous occasion. In conclusion, it is all your collective support, dedication, and participation that have made this 20th International Seminar a memorable and enlightening one. Thank you. Thank you, one and all.
Thank you so much, sir, for expressing your heartfelt vote of thanks to this valedictory session. I also take this opportunity to extend my gratitude towards you too for your contribution, sir.
As the famous saying goes, where there is a stepping stone, there is a milestone.
Indeed, Rukmini, that's exactly what took place in today's virtual dais, where we have accomplished another outstanding step towards grasping the dynamics of climate change. With this, we conclude our 20th International Seminar on exploring about climate changes and the rights, issues, and challenges. And now, I would like to convey our deep appreciation to Advocate Nagaraj Narayanan Sir, Director, Kerala Law Academy Law College, and Professor Anil Kumar K. Sir, Director, Administration, Students, and Faculty Affairs for this fantastic opportunity and the never-ending support throughout this journey.
None of this would have been achievable without the generous backing and guidance of people working behind the scenes. Your collective commitment and hard work transforms this international seminar into a successful and enlightening event. With this is Rukmini
and Srinidhi
signing off. Thank you and have a pleasant evening.
I would like to request everybody to rise up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय जय हे जय हे जय 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 हे